We invoked the original jurisdiction of Supreme Court when there's a dispute between the state government and federal government. It's one of the few occasions where Supreme Court has the original jurisdiction. So we invoked the powers of the Supreme Court to hear this application. The reason for it is that as well-intentioned as this policy of federal government of redesign is working hardship all over the country, as we can all see, banks are being harassed, Nigerians are suffering needlessly, especially the downtrodden. Those in the urban areas, they're having problems, but it's more excruciating at the rural area. So these three state governments, Kaduna, Zamfara, and Kogi, deem it fit for us to invoke the powers of Supreme Court to intervene. And the Supreme Court are not just the final court, but a court of policy. In its considered ruling, saw merits in our application and restrained the federal government and, by extension, the Central Bank of Nigeria. The old note that we all have is still a legal tender beyond the 10th of February that the federal government said is no longer with legal tender. So the old note, as we speak, the Supreme Court has spoken, and Supreme Court is the last court, is the final court, is the appeals court. It has said that 10th of February is no longer operative.
No, the other is an ex parte, and because of the urgency and the affidavit of urgency filed by the applicants, the court in its wisdom decided that something must be done because of the urgency. But the court has rightly, in its own wisdom, directed that all processes must be there by 15th, that is Wednesday next week, for us to argue our various positions.